Patentes son
Patents are the results of generative AI. Protected TARSO MACHADO from Brazil and McCracken, professor of New Hampshire Franklin School of Law, United States. MC Yvonne Hernandez, director of the intellectual property area of ARIAS, Guatemala. Good morning. It's a pleasure for me to be here with you and moderate this panel. For this to be more fluent, we're going to present it in English.
And TARSO for preparing such a complete overview about how AI is contributing to the construction of patents and the protection. As you're going to see, we're going to talk about the role of AI in the conception of patents. Also, we're going to tell you how the different countries are treating AI for granting patents. And we're going to go through the guidelines of the USPTO. We're going to give you some examples and explain some scenarios that have been prepared in the guidelines of the US. So we know that you are going to exit with a different criteria of your own about the patent world and AI. So let's begin with TARSO. TARSO, time is yours.
Thank you, Yvonne. Good morning, everyone. And it's finally time to talk about patents. And let's get it started because we have a lot of information to share. So I would like to start with this graph here. It's from WIPO, and there's a timeline with some key events on the history of AI. So we can see that in 1956 is the moment that the first time that the term AI was mentioned. And we can see at that time there was no patent filings for that. And from 1993, AI became data-driven, and computers are starting to have better hardware and computing power. And we see that that's where like machine learning and what's the idea of AI that we have today has started to emerge. So we can see that at that moment, we see a small increase in filings for AI. And in 1994 is when Dr. Stephen Tyler, it discloses the creativity machine. And I would like you to keep in mind this name because I'll go back to Dr. Tyler a few times during my presentation. And we can see that after that, we have from 2012, we have increasing in data publicity and the availability of data to train AI models and the increase in computer power, we can see that we have this AI patent boom. So in this moment, we start to see AI shifting from the theoretical field and start to actually have impact in terms of solutions that are actually useful for day-to-day life. So in this moment, when AI shifts from the academy to the actually market as products, as useful things, we can see that it's a consequence that we start to see a lot of patents. And in 2022, as some other panelists has mentioned, that's where ChatGPT is first launched. And then we have the generative AI patent boom. So I also like, this is something that was already explained by other panelists, but this is some just very quick definitions. So we do have this difference between what we understand as a regular AI and the generative AI. So usually the idea of the AI that we have learned before generative AI is systems that are trained to classify information. So if you have an input as a dog, we have a discriminative model that is able to classify if that's a dog or not a dog, or maybe a cat or person, and for example, facial recognition. And generative AI systems, on the other hand, we have the ability to actually create information from an input. So if you prompt something like a dog and a generative model, it's able to create like an image of a dog, as was explained, for example, in Midjourney, right? And something that's interesting to think is that although how we learned about generative AI, it's usually related to the chatbot, like in ChatGPT, this is actually an essential feature for generative AI. It only needs like a prompt. You don't need to actually have a chatbot that would interact with you in something like a conversation. So another important definition here is the difference between AI-assisted inventions and AI-generated inventions. So for the sake of my presentation, I would like to focus on the AI-assisted inventions where AI is an integral part of the technical solution. So it's a tool that is part of the solution that's in the patent application. Okay, so for example, for a facial recognition system. Some other specialists, there are some broader definitions. For example, AI-assisted inventions as an inventions that AI assists in the inventive process, but are not necessarily part of the solution. But for my presentation, let's focus on this thing. And AI-assisted inventions, they are the current concern of patent offices when we're talking about examining patent applications for AI-related inventions. So they've been trying to create some rules to better rule how those inventions can be protected, how this application should be drafted, and what patentability requisites should be met. And on the other hand, AI-generated inventions are inventions where the technical solution is generated by AI. So we have here AI as inventor, not AI as a tool. So in this case, the human intervention does not exist or is just minimal. And of course, this raises the question of inventorship. So I'll start talking about the patentability of AI-assisted inventions, and I would say that this is an ongoing discussion in the present. And why is that? This is just some other information for WIPO. These are just patent filings up to 2019. And we can see that there are many, many thousands of applications that are filed for AI-related inventions. So of course, most of the patent offices that have been receiving more applications are US, China, EPO, Korea, and Japan. These are what we call the IP5 offices. They are the biggest IP offices in terms of patent filings. And from Latin America, we can see there below, we have Brazil. At that moment, from 2019, we had about 5,000 applications for AI-related inventions. And I brought this information here just for you to have in mind that we've been already receiving a lot of patent applications for that. So this is an ongoing discussion. And regarding AI-assisted inventions, what I can say is that patent offices are not concerned in evaluating if the invention was actually developed by a human or a computer. So provided that a human inventor is listed in a patent application, the application is examined as in other cases. And for most patent offices, or AI-related or AI-assisted inventions, they are being treated as computer-implemented inventions. So most patent offices, they've published in the past examination guidelines to rule what are the rules of patentability for computer-implemented inventions, and they now have been updating these guidelines to address the particularities of AI. And as I said, the technical examination does not consider the participation of inventors, of the expertise of inventors. This for AI is the same for regular inventions, right? It doesn't matter if the inventor has worked for 10 years to develop an invention and it was kind of a flash of luck or maybe just one day that he took to develop an invention. That doesn't matter for patent offices, and this is the same for AI-related inventions. So, as I said, patent office have provided guidelines for examining those patent applications. And the main three things that we have to have in mind when we're talking about patentability of AI-assisted inventions is eligibility, sufficiency of disclosure, and inventive step. So those are the three usually main concerns of how we should examine patent applications for those inventions. So when we think about eligibility, most patent offices or national laws, they usually establish what is a non-statutory subject matter, right? So what's not patentable, what's not considered an invention. And there is some harmonization here, and most patent offices, they would say that mathematical ideas or abstract ideas and computer program per se, the source code, are not considered inventions. And as I said, most patent offices have been considering that computer-implemented inventions are eligible when they are technical in nature and not abstract. So usually we see AI-related inventions as computer-implemented methods or as systems. Some jurisdictions accept computer-readable media, which is the media that maybe have the computer program stored, right? So these systems and methods and the technical solution that when performed by software are patentable. And on the other hand, the source code and the authorial expression of the technical solution, for example, in the source code, this is protected by copyright, this is not eligible for patent protection. When we're talking about sufficiency of disclosure, this is something that's very particular for AI because I think we've seen this yesterday, that AI system, we do have this capability of the system to be adapted during training. And this adaptation, it's usually the weights, right? The numbers that are being adapted in response to the input, and this would adjust the system features so that after training it's able to recognize a pattern or able to generate information. However, after that, after the training, it's very, very difficult for a human to understand how actually that system is able to provide that technical solution. So usually what happens is that applicants must provide information on how the training has worked. Okay, so most patent offices has been asking, as our general rule for sufficiency of disclosure, is that applicants must provide a clear and precise description of the invention, of course, but for AI, it's also necessary to provide information regarding training, including the description of the data and how the system is trained. So we have here these two examples. So this is a very traditional neural network, and what we should try to put in the patent application is that how the system is trained so that it's able, that for that person skilled in the art, it's able to read your patent application, understand how to train that system, and consequently how that system would be able to solve that technical problem. And we should avoid this, what is called a black box solution. A black box solution is if you basically put an input, you don't explain how your system is able to classify that input or generate a new input from that input, and you only put in an input, a black box, and an output. So that would not be enough for a person skilled in the art to reproduce your invention, and consequently, your application won't attend to the requirements of sufficiency of disclosure. So it's important that you should provide at least one example of training information, and the source of the data, although it's desirable, it's not mandatory. And this is important because the data set that's used to train AI, it's often a very sensitive and important information for the applicant. So if you're talking about information from medical data from patients, this is something that you don't want to disclose in your patents. And if it's maybe the data set itself, it's a very valuable information for your client, so you don't have to disclose that in your patent application, but at least you should provide an example, at least maybe an abstract example of information of how that would work. And and lastly, for inventive step, what we have here, it's common for most patent offices, is that in order to have inventive step, the information cannot be obvious for a person skilled in the art. And it's interesting to think about person skilled in the art here is the same definition that's used for sufficiency of disclosure, right? So the sufficiency of disclosure, it's the amount of information that you have to put in your patent application for a person skilled in the art to be able to read it, understand it, and reproduce your invention. So this person is the same person that has to be considered when we are talking about inventive step. And we should be careful because nowadays with how AI is spread, the benefits of AI are considered as within reach to all technical fields. So if you're merely replacing something that was in the past being done by a deterministic method, a non-AI method, and you're just replacing that by AI, a non-AI method that would be likely considered as not inventive. Or if you're just replacing a non-AI model for another AI model, that might be considered as obvious as well. Of course, if you can prove in your patent application that that difference is inventive enough, it's not obvious because there are some particularity that's not that easily to replace one AI algorithm by another algorithm, then it could be considered as inventive. But just mere substitution of non-methods would not be considered as inventive, okay? So these are just some example, a chart from the understanding of United States, CPO, China, and Brazil. I won't go through this for the sake of time, but I believe you received these slides after the seminar, so just for some reference. And now I'll move forward to the patentability of AI-generated inventions. This is something that I've put as a necessary discussion for the future. Okay, so now we are moving from the inventions that use AI as a tool, and we're talking about here, and I think this is the focus of the panel, about when AI actually develop a solution by itself. So there in the bottom some interesting reference about that, but I would like to start with these statements here. So computer and AI have been participating in the innovation process and in the patent system for many years. And Dr. Thaler, that person that I mentioned in my first slide, the creativity machine that was disclosed in 1994, has created an invention that was filed listing Dr. Thaler as the inventor. And such patent was filed in 1996, and it was granted by the APO in 1998. So the AI system has invented an invention. A patent was filed, but including a person, the name of a person in the patent application, and the patent application was granted. And there are some other examples in this reference in the bottom. So what that means is that applicants are probably not listing the AI system as inventors in view of uncertainty regarding patentability of AI-generated inventions. So in some cases, we might see that AI is actually just being part of the solution, and in some cases, as in this case that is mentioned by Dr. Thaler, the invention was actually basically 100% developed by AI, and it was granted. And this is a case that was actually disclosed by Dr. Thaler, but in many other cases, we can probably have patent applications that were filed. There is a name of an inventor there, and we don't know if that was actually 100% true, that the inventor was 100% responsible for the creation of that invention. And then the first question that I would like to bring here is that, is this fair for human inventors that are actually being the person that's responsible for 100% of the work in the inventive process? Is it fair that when a human is using an AI, and when AI is responsible for most of the inventive process, if that person can be listed as a sole inventor of that invention, is this fair to the other inventors that are actually working and are 100% responsible for those inventions? So now I would like to talk about a very famous case, that is the Dabus case. And it was a case that was filed mostly to challenge the patent system. So this is the PCT number of this case, and the difference between the Dabus case and that application that was filed in Dr. Thaler in the 90s is that in this case, the inventor of the patent application was listed as an AI system, so that there was no human inventor listed in that patent application. So then what happened to the patent family, it was actually filed in many jurisdictions, and it was denied in most of them, as you can see. So it was only granted up to now in South Africa, because South Africa, it basically has a formal examination system. So this was not an issue for them, but in their law, it's required that the inventor must be a human person. So this application could even be invalidated in the future. So, and the sole reason that this application was denied is that there was no human inventor in the patent application. So the family of the Dabus case was denied. And now we can think about why this case was the difference between Dabus case and that first patent that was granted in the 90s is that there was not a human listed in the patent application. But both inventions were developed by AI. And now I'll move to some other hypothetical case for us to think about here. And of course, when we're talking about AI, we are always raising a lot of questions and not that many answers. So this is actually my dog, and I actually forced her to take this picture. But let's say that you're person A and you work in the shoe business. So this is Lena, that's my show, and let's say that she has the habit of shoeing shoes, that I'm glad that she don't. But person A leaves her sneakers in reach of the dog, and she removes the insole and starts shoeing the shoes. And when using the shoes throughout the day, you notice that the moisture in your feet reduces because of the holes in the insole, okay? So after realizing that, this person A tries some different roles and sends this for manufacture. And then you have this insole with holes that is a new product. And then it raises the question that is it fair that this person is considered the inventor of this patent application? And if it is, why not the person and not the dog, right? What's the participation of a person in this case that it just discovered or realized that that thing that happened was potentially patentable subject matter? And scenario B, let's look at another example here, and it's an example that has two scenarios. So let's say that person A and person B, they are both engineers. And person A would like to develop a new camera app for better photo quality in the dark. And then this person A tells person B that this desire and provide person B with some public documents explaining about some other solutions in the state of the art. And through his search, person B managed to develop a new and inventive app. And in this case, we might think, oh, would person A qualify as inventor in this patent application? And I would say that in most jurisdictions, the answer is no, because the sole fact that person A expressed its desire, his or her desire for a new technical solution, but person A didn't participate in the conception of an invention. So this person would not be considered an inventor, and the only inventor would person B. And now imagine scenario B, and we will basically replace person B by a generative AI system. So instead of telling person B, person A would use this generative AI system that is trained with some public documents as well as most generative AI system does. And through these generative capabilities, the generative AI then comes with a solution that's a new app which could provide better quality at dark. And in this case, would person A qualify as an inventor? So what is the difference between this scenario B and scenario A? The participation of person A would be the same, right? However, in this case, should we consider person A as inventor because there's no person B here? should this invention not be considered patentable because there's no inventor, although the technical solution that was provided in both scenarios are the same? So, and I would like to bring some just final remarks here, is that AI-assisted inventions and AI generated inventions should be treated differently. So AI-assisted inventions, and then this more restrict definition that I was talking about here, that is AI as part of the technical solution, this is already a reality for at least 20 years, sorry, for at least 20 years. So thousands of applications are being filed for inventions that use AI. And these are being the work of patent offices that they've been trying to develop harmonization and well-established patentability requirements. On the other hand, AI-generated inventions are a discussion that we should do here, but it's more like a discussion for the future, right? Should states change their law to allow AI inventor, as in the Dabus case, right? And if so, what about harmonization, right? Because it wouldn't be of much use if a single country says, okay, we will allow AI as an inventor in a patent application. But if all the other major offices or patent offices, they keep their current understanding that AI cannot be an inventor, then it won't be that much use, because then you file in one country, it gets granted there and denied everywhere else. As I said, AI-assisted inventions are being treated as computer-implemented inventions with some additional challenges that are being tackled by the patent offices, such as the sufficiency of disclosure, right? What is the necessary information that we should put in a patent application in order to enable a person skilled in the art to reproduce an invention? And although the Dabus case was was a very important case and listed an inventor, AI as an inventor, we believe that there are many applications that are being filed and the participation of AI is being omitted, okay? The patent system, as you all know, it's designed to promote innovation by granting inventors exclusive rights to their inventions for a limited period. And some people some specialists that are against the allowability of AI as an inventor is that they think that AI doesn't need this incentive, right? AI don't need to have the desire for a patent to invent something. However, although AI would not be motivated to invent by the reward of a patent, patents for AI-generated inventions would motivate computer science to develop new creative machines. So the development of new generative AI like ChatGPT would be promoted if we allow AI as inventor, because then if you can have a system that can produce patents, then the systems are more valuable and people would invest more money in that. And permitting AI as an inventor, this would also probably would promote disclosure of information, because in a scenario that will not allow the inventions generated by AI to be patentable, probably those inventions will then be kept in secrecy, because if you cannot patent, people will try to not disclose it. So I believe actually that if we start allowing AI as an inventor of patent applications, this would, one, make applicants to actually disclose the participation of AI in their patent applications, and two, it will allow people to keep filing patents for those inventions. And lastly, it's something that it's good to remind here, is that we are talking about AI as an inventor of a patent application, and not AI as an owner of a patent. So computers cannot own property, and it's safe to assume that self-conscious AI and computer personhood are not happening in the near future. So maybe next time that we're here in the Las Antiguas, we might be talking about this, but this is not for today. And some additional questions that I would like to just put here for reflection, but we don't have time to address those, is that in case of patent offices allowing AI to figure as an inventor, who should be the owner of the patent? Right? Should be the programmer of the AI, the creator of the AI, should be the owner of the AI, or should be the user of the AI? So these are some other questions that could be raised from the point that maybe patent offices start accepting AI as an inventor. Should the technical examination be different for those applications that has an AI as an inventor? And what would be the person skilled in the art, right? So if you have, when we're talking about sufficiency of disclosure, inventive step, we have this perspective of a person, because those criteria were developed by persons. So when we're talking about AI as an inventor, should those criteria apply? And on the other hand, if you start using more rigorous criteria for examining patent applications invented by AI, then we might go back to the beginning, to the fact that, okay, if it's harder to get a patent when you put AI as an inventor, then maybe I should put also a human being as in the list of the inventor, or maybe I should omit the participation of AI, because by doing that, if that, in this hypothetical case, if my patent would be analyzed by different criteria, by having an inventor, maybe applicants would keep omitting their participation of AI. So this is some considerations to have. Okay, so now I'll hand over to Anne.
Yes, we are going to leave the questions until the end to save some time. And we're going to follow with Anne, who's going to present us a more US perspective about this topic.
All right, hello everybody. So I'm a US patent attorney. I've been practicing for over 25 years, getting close to 30 actually. I'm also a professor at the University of New Hampshire, which oddly enough, TARSO, that conference you mentioned in 1956, which was the first time they referred to the field of artificial intelligence, happened in New Hampshire, at Dartmouth, not far from University of New Hampshire where I teach, which I think is kind of cool. So the US just recently issued guidelines, or guidance, correct me, guidance, on the use of, or inventorship in the context of AI-assisted inventions. And I'm going to talk about how to apply that today. But before I do that, I just have a question. How many people in the audience do some patent prosecution as part of your practice? Can I see a show of hands? Okay. So as we go through this, I'm going to ask some more questions for a show of hands. And now I know how many people should raise their hands. So I got that out of you. You didn't even know I was going to get that out of you. Okay, let's get started. This is how I always start my classes, with let's get started. First, a real quick overview. By the end of my part of this talk, you are going to be able to analyze inventions created with AI assistance for inventorship. You're going to be able to examine, and this is what we're going to do today, you're going to examine the role of the human contribution in an AI-assisted invention, and then we're going to evaluate 5 different scenarios for inventorship based on and applying these recent USPTO guidelines. So at the end of this, when you go to lunch, you will know how to do all this stuff. So I'm going to start with a little bit of background on the guidance that came out of the USPTO. And I created this image because it shows just a computer. And the context here, we'll start with the Thaler decision. So the Dubas case that TARSO talked about was in the US, Thaler versus Vidal. So they filed an application with the USPTO, listed only a computer system as the inventor, and the Patent Office rejected it. So that was appealed to the Court of Appeals for the Federal Circuit. That became the Thaler versus Vidal decision, and the Federal Circuit in 2022 upheld the Patent Office's decision and said that only natural persons can be named as inventors under US patent law. But there's an important issue that they didn't comment on. So that gave us a clear rule on the question of, can you have just a computer system be listed as an inventor? And the answer is no. But what they didn't comment on is the question of whether inventions made by humans with the assistance of AI are eligible for patent protection. So that's what we're going to look at today, and the USPTO came out with guidance just in February to help us out with their view on this. So their view at the high level is that AI-assisted inventions are not categorically unpatentable for improper inventorship. And the guidance really emphasizes the importance of the role of the human involvement in the process. So I've included at the end of this slide deck a couple of links so that you can actually go to and review the guidance if you want to take a look at it in more detail. But the high level, the key takeaways are patent applications for AI-assisted inventions in the United States must name a natural person who significantly contributed to the invention as an inventor or joint inventors. So that significantly contributed is the key language. And we're going to look at some examples, and you're going to help me figure out if a human is significantly contributing to the invention or not. The other key takeaway, and it's really kind of the same thing, just said a different way, is that patent applications must not list any entity that is not a natural person, so a computer, as an inventor or a joint inventor, even if that AI system was instrumental in the generation of the invention. Okay, so the way this analysis is done in the US to figure out if there's a significant contribution is something called the PNU factors. And these aren't new, they've been around for close to 30 years. This is how the US determines when a second or third or fourth inventor should be listed as a joint inventor, whether somebody's activity rises to the level of joint inventorship. So there's three things that contribute to the PNU factors. The first and the most important is that you have to contribute to the conception of the invention. And remember, conception's what it's all about. You have to have that aha moment where you contribute to that conception to be an inventor. Then also it has to be something more than an insignificant contribution. And finally, it can't be something like just restating the state of the art or something that's generally known. So that's what they look at to see if somebody is considered a joint inventor. And that's what the US Patent Office is leaning on in their guidance to figure out if a human is meeting that significantly contributed to standard to be listed as an inventor when they're working in combination with an AI system. Okay, so now let's jump in and let's look at how to analyze inventions made by humans with the assistance of AI. So here we got the human and his computer that's working with him, the AI system. Now, in this case, I want you to assume that you have a client, XYZ Toy Company. XYZ Toy Company makes remote control cars. And you have two inventors in your company who you're working with on some patent applications, Ruth and Morgan. They're engineers, they're working on a product for a transaxle for one of these cars. So in the first scenario, they just prompt an AI system to, and I've got the prompt here, to create an original design for a transaxle for a model car, including giving schematics and a description of the transaxle. So the AI system outputs a design with a casing, a transmission, the axle shafts, some information about all that, includes all the details that they asked for. Ruth and Morgan look at these and they say, yeah, that's pretty good. I think that'll work. So you have a claim to the system, or to the transaxle, that is described by the output of that AI system based on the prompt that Ruth and Morgan entered. And here's the claim. It's a claim to this transaxle with the casing, the transmission, the axle shafts, the fasteners, all the parts to it. Okay, so here's my question for you guys. Are Ruth and Morgan inventors in this situation? We've got Ruth and Morgan right there typing in the prompt for the AI system, and we've got the AI system's response with a schematic and the details of the invention that they've decided will work and that became the basis for that claim. So by a show of hands, how many of you think or would say that they are inventors? Raise your hand. Okay, so we got a few. All right, now how many would say they are not inventors? Raise your hand. Would you say, I think we have more people for no than yes, is kind of my count. All right, well, let's find out. Here's how you analyze it. First, wow, so I'm getting older and I can't see my print that well from here. It's no fun getting older. Okay, so the first factor, did they contribute significantly to the invention? Well, in this case, they recognized the problem, they created a prompt, and they reviewed the output, but that doesn't really rise to conception of that transaxle as it's claimed. And then their contributions really were not significant to rise to the level in that second Panu factor, and they really just didn't do much more than contributing to or restating the current state of the art. So in this scenario, they are not inventors. But that's okay if you didn't get that one right, because we got 4 more chances. So let's keep going. Here's the next scenario. Now, they take that output, that schematic design, from that prompt in the first scenario, and they build it. They hadn't built it before. So now they build it. They don't alter the design at all. They just build it the way the system, the AI system, said to build it. But the system didn't tell them what material to use. So they make the selection themselves. They make the decision, we're going to build it out of steel, because that's a common material for transaxles. Okay, so there's a claim that you put into your patent application based on the fact that they chose the material to be steel. So we have a dependent claim where the casing is constructed of steel. We need to figure out if Ruth and Morgan are the inventor on that claim too, because they're not inventors yet for claim 1. So are they an inventor for claim 2? Here's Ruth and Morgan. She's changed her hairstyle a little bit since we last saw her. But they have now reduced this to practice. So that's the physical transaxle system. So again, show of hands. How many would say Ruth and Morgan should be listed as inventors now based on that claim 2 to the fact this is made of steel? Raise your hands. Okay. How many would say they still haven't done enough to be inventors? They are not inventors. Okay, I think we still have more for no than yes, would you guys say? All right, let's find out. Okay, in this analysis, what they have done is they have reduced the invention to practice. But under the Panu factors, just reducing an invention to practice is not enough. They still didn't contribute to the conception of the product. The conception came from that output of the AI system. They just reduced it to practice. They did select steel, so that was their contribution, but that didn't rise to the level of being a significant enough contribution because steel's pretty common, well-known material for this kind of part. So they don't make it in based on that either. They really haven't done much more than apply what is the state of art. So in this scenario, they are still not inventors. Okay, now they continue. And now they go back to, and this is the name of the AI system in the USPTO guidance. It's called Porto 5. I don't know why they picked that name. This could be ChatGPT, it could be Claude, it could be Gemini, it could be any of these systems that are out there. But that's the system and name in the USPTO guidance. So they go back, and now they ask for some alternative designs. And the system generates another design for them to use. And they decide to build this design and reduce it to practice, but they have to modify it a little bit, and they have to do a little bit of experimentation, and they change things a little bit. For example, they determine that the casing needs to be different, and so they've now modified this. So the claim is another independent claim to the transaxle. It's a little narrower than that first claim 1 that we have. And I put in red a few of the things that are different because I was able to line claim 1 and claim 3 up, but you can't see both of them at the same time. But you can see that there's some features that are different in this claim to the transaxle now for independent claim 3. So here we have Ruth and Morgan. They had prompted the system for a new design. That design is shown on the screen, but what they ended up building is different, and that's on their desk. So they modified this, they came up with their own modification to that design. So are you gonna say that Ruth and Morgan are inventors on claim 3? Yes or no? So raise your hand if you say they are inventors on claim 3. Okay. How many would say they are not inventors on claim 3? Okay, it looks like that's flipped now. I think we have more people saying that they are inventors. I wish I'd brought a prize for if anybody got like all 5 of these right. I didn't think to do that. Okay, let's see. Yes, in this case, they are inventors because they've now contributed to the conception of that design because they had to modify it. They kind of came up with their own design of the product, and that rises to the level of a significant contribution by a natural person. So the changes that they made are something more than being insignificant. There's something more than just applying the state of the art. They actually contributed to the conception and made a significant contribution to the overall. So they are inventors for claim 3. All right, now they start to get kind of hard. Let's look at the 4th one. They've got this new model that they created that we've just claimed in claim 3, and now Morgan wants to get some ideas for how to manufacture it. So they go back to their AI system, they prompt it and ask a question, how to best manufacture this. And they get a suggestion that it could be milled out of aluminum. The transaxle could be milled out of aluminum using a CNC routing machine. And Morgan recognizes that these are pretty conventional machines for fabrication of parts like this, and they decide to go ahead and do this. So you put a claim into your application that now we've got a casing made out of aluminum. The suggestion of aluminum came from the AI system when it was asked for recommendations on how to manufacture this part. So here we go. Ruth and Morgan are asking the AI system for recommendations on how to manufacture the part. The system's coming back with the suggestion to use this CNC machine and to use aluminum. So in this scenario, that dependent claim 4 are Ruth and Morgan inventors. And I'm going to give you a hint. Remember, we were looking at a dependent claim. Just going to give you like 5 seconds to ponder this one. Let's go back to that dependent claim. Are they inventors on this dependent claim? Did they rise to the level of a human having a significant contribution? All right, raise your hands if you say yes, they're inventors on this claim. A few. All right, raise your hands if you say no, they are not inventors. Okay, a lot of people say no. They in fact are inventors. I tried to help you out. I tried to give you a hint. It's a dependent claim. So all the elements of claim 3 where they were inventors, plus dependent claim 4 It's the claim as a whole, right? They're looking at the invention as a whole. So they did contribute a significant part to claim 4, which is the design that's in the dependent claim 3. And then, no, they really didn't contribute much to claim 4, to the element that was added, but that's just a small element that was added. The overall invention, so if you look at the invention as a whole that's claimed by claim 4, they were the human contribution to a significant part of that invention. And so they are inventors. So I'm curious, do we have anybody still in the room that's gotten all 4 of these right so far? Anybody? Oh, we got one person here. Okay. All right, then you better get number 5 right. So I want somebody to get 5 out of 5. Okay, so now we're looking at kind of a different thing. For this next question, we've got another person. His name is Maverick. He's the lead engineer who developed that Porto 5 system. He developed the AI system. And so, he trained it, he selected the materials to train it, he, used standard supervised learning techniques to do it. When he was doing it, he was completely unaware that your client, the XYZ toy company, was going to be using this to solve the problem of making a transaxle. He was just building an AI system. So, because he built that system, though, we need to go back and look at claims 1, 2, 3, and 4. Is he an inventor on any of those claims? So here we have Maverick. He's working on the system that he built. You see there's no transaxles on his computer screen. He's just developing an AI system. Is Maverick an inventor? Raise your hand if you think yes. Anybody? Couple? All right, raise your hand if you say no. Okay, several people say no. So I think you got 5 out of 5. The answer is he is not an inventor. So his contribution was limited to the creation of the AI system, but that had nothing to do with the conception of the invention itself. He was just doing work that really wasn't specific to the invention at all, so he is not an inventor. It doesn't mean that those AI systems aren't patentable. That's a whole different deal that gets into like the computer implemented invention criteria that TARSO talked about. But in the instance where we're looking at the output of an AI system and whether or not that is patentable and whether there's a human contribution, he has nothing to do with that. So he would not be listed as an inventor in that case. So, just to summarize, first we had Ruth and Morgan prompted the system for a design. That was a minimal contribution. They were not inventors. Second, they took and they reduced to practice the design that the AI system generated as a result of that prompt, but their contribution was still minimal, so they are not inventors. But then on scenario 3, Ruth and Morgan took the design that the AI system created, but they modified it. And modified it enough that they basically created their own design. Now they became inventors, and the fact that they used an AI system doesn't negate the fact that they developed something and conceived of a new thing. They are inventors. And that fourth one, that was tricky. The fourth one, they were still inventors, even though that was a dependent claim, but that was because of the contribution in the independent claim. So, those basics, we all learned back in school at one point that the independent claim incorporates everything in the dependent claim. Don't forget that. And then scenario 5, Maverick had nothing to do with this. He just developed the AI system that they use. So, if you're going to take some guiding principles away that you can use when you're working with your clients, this is the list that I would give you. First, prompting an AI system does not typically make somebody an inventor. But I'm going to say typically, because even in the USPTO guidance, they do leave open the idea that maybe somebody could have a very sophisticated prompt that results in a very specific output, and the creation of that prompt was significant enough in producing that final output. So I'm not going to say that's always a no, but typically, just prompt something, ask it for a design, that's not going to be an inventor. Then second, reducing something to practice is not enough to make somebody an inventor, and this is not new. It's whether it's an AI-assisted invention or not, reducing to practice doesn't make you an inventor. Third, this idea that using an AI system doesn't negate a person's contributions is important. What you have to look for is that significant contribution. If the person has a significant contribution, even though they did it in combination with an AI system, they still qualify as an inventor. And then the last one, overseeing or developing an AI system does not make one an inventor for the outputs of that system later on down the road. So those are the guiding principles. In conclusion, 2 takeaways based on the guidance. Significant human contribution is what the USPTO is looking for now to determine if you have a human who can be named as an inventor in an AI-assisted invention. And those PNU factors are what the USPTO uses to determine if an invention has a significant enough contribution from a human to qualify them as an inventor. And if you want more information in my slides, I've got links. The USPTO has actually a great landing page now with resources on artificial intelligence. All this stuff about inventorship, they've got a lot of materials. They've got the examples that I just went through. They also have another very detailed example that's more life sciences oriented. And that's not my field, so I didn't try to take that one on. But they have a really good one about a therapeutic compound of some sort that walks through the same things we just walked through here, and that's posted on that AI landing page. Then the specific guidance you can get to from that AI landing page, but I have the direct link there. And if you really want to go read the Thaler decision or back from 98, the PNU decision, I got the citations to those as well. So those are all the resources I looked at preparing for this. Anyway, thank you very much. I love ChatGPT because it takes many, many years off photos if you ask it to generate an image to use for yourself. So I look a lot younger there. All right.
Thank you. And before opening to questions, I would like to know your thoughts. As we have seen that for AI, similar to other fields of the industry, where not everything is patentable, but some things are. But for AI, one of the challenges is inventorship and some other things, as we have seen. But do you foresee that it will be necessary to have a sui generis system like in other topics of IP?
Do we need a different system for figuring out whether there's AI, to determine the inventorship in an AI system? Is that what you're asking?
Yes, separate from patents, like for the UPOP systems, for instance.
Oh, sure. No, I don't think so. I mean, I think we have a framework here that we can deal with, and I think it's pretty well defined at this stage. So I don't think we're going to have a separate system for AI inventions. Really, I mean, down at the underneath it all, it's just software. And software is the area that I practice, and I think that still fits all the frameworks that we have.
Yeah, I agree with that. And I think when some specialists that have been talking about the sui generis protection, they are usually we're talking about copyright, and these specialists, they think that we should have some sort of protection for creations from AI when it comes to copyright, because I'm not a specialist in copyright, but the right emerges from creation, right? There's no, you don't need to file a patent application, and it doesn't need to be granted. So if we allow copyright for AI-generated inventions, AI would just create everything, and out of the sudden, everything could be protected. But I don't think that would apply that much for patents because we still have to file, we still have to, that invention has to meet some patentability criteria. So I think the framework, and then if we should allow AI as inventor or not, that's a different question. But AI-generated inventions, if they are allowed because of the participation of a human or not, I think the patent system would be enough for that because there's the need of filing. It has an autarky, a patent office that would evaluate that. So I'm not sure if that would be as necessary. I would say that if you're talking about protection for AI creations, this is important for copyright, not that much important for patents.
Thank you so much. Now let's open for questions from the audience. Please, if you have any questions, raise your hand.
Hi, good afternoon. Thank you for everything. You've been, excuse me, it's been very helpful, all the information you've given us. Maybe it's more of an opinion that I'm requesting for you rather than a question, but I'll be brief, but I'll try to give some context. I did some research, and I know that most jurisdictions pretty much agree on the non-human inventorship issue. But on South Korea, as it turned out, at some point, it was explained, maybe an oral hearing, deposition, I don't remember, but it was explained that the actual output of Davos, and I'm talking about Davos, sorry, give some context, wasn't as straightforward as one might think, just like a regular inventor that you ask for an inventor disclosure and everything is explained. What happened was that the output was a long list of sentences and graphics that had to be compiled, reviewed by a patent attorney to have a final patent application. And taking into consideration that when you look at the Davos application, you actually have two different inventions, both based on the same fractal geometry principle, but there were two distinct inventions, which in the US would probably require a restriction requirement. So that begs the question, basically two things. What kind of data, what use during the training for Davos, and what was the intent, right, for using Davos? Because, which I don't know, and maybe Taos, you can give us some insight. But what I'm saying is that if the person had a specific purpose of using Davos, like I have this problem and I'm going to use all this training data that is somehow related to the problem to see what the output is, then that person, let's assume is the patent attorney, will be more directed and will know exactly what to look for, right? When organizing everything, and might be considered probably a non-significant contribution, and to that extent probably Davos will be the inventor. But what about if this was just random data, and then with random output, let me see what happens there. So, and this is the question that I would like to have your opinion. Based on those facts, if the person that trained the system using the random data to see what was out there had to spend many hours trying to figure out if it was something patentable there. Now, would that be considered, and that person will draft the application, would that person then be considered an inventor which used artificial intelligence as an assistance?
Well,
thank you.
Am I on? Okay. So I always get asked a question by my students about what happens if I, as the attorney or the patent attorney, add something that my client didn't think of. And that's kind of what's coming in the back of my mind as I'm listening to you describe this. It's the scenario where the attorney gets something from their client, and then the way the attorney synthesizes it, they come up with something that is claimed and claimable, and then the question is that attorney the inventor or not? Which is, that's a whole nother set of issues there. But I mean, just looking at the guidance, you know, if you have data, somebody's synthesizing that data in a way that generates or produces some kind of a result that is not insignificant, right? It's a significant contribution. I don't think the guidance precludes that. Like, the guidance doesn't shut the door on a lot of things. It gives a series of examples on how to handle it, but there's a lot of wiggle room left in this guidance for even things like maybe we might be able to claim prompts someday if there's certain prompts that are have enough of an influence on the output. So I wouldn't say that that is precluded today. I think there's still a lot of open issues, but I don't think there's an absolute no to what you're describing. And I'd recommend that you read through and look at the guidance and take away your own opinion on that.
Yeah, I think that's a very interesting thing and reflection, but I would say that, let's say that the generative AI, it generates a lot of solutions, but and you have to maybe look at that and think about how you could apply any of those solutions for something. And then the applicability of that solution was not that clear from the generative AI, and you just said, oh, this could be useful for that. Then in this case, that could mean some significant, because the solution just produced some random output, and you actually guided that output for the solution of a technical problem, for example, that was not that clear from the AI output. And for the Deb's case, as far as I know, Dr. Thaler, it alleged that it was almost without many inputs. So, but of course, there's the creation of the invention, and there is the drafting of a patent application, right? So these are two different things. But I would say that if the output, it's a bunch of solutions for something, and then you identify how you could apply that into something, then that could be enough to qualify as an inventor.
Thank you, and thank you all for your attention. Due to time, we cannot address more questions, but our panelists will be over here if you want to ask them any question over there. Thank you very much for your time, and have a great time this afternoon.